Good morning, good afternoon, or good evening for those of you listening in various time zones or listening to the recording at a later time. I'd like to welcome you to the National Public Scoping webinar on defining the scope of the Migratory Bird Treaty Act. My name is Eric Kershner. I'm the branch chief for conservation permits and regulations within the U.S. Fish and Wildlife Service's Migratory Bird Program. I'll be your presenter today. I'm also accompanied by additional U.S. Fish and Wildlife Service leadership within the Migratory Bird Program and members from the Department of Interior's Office of the Solicitor. We operate out of our headquarters office in Falls Church, Virginia. Also here with me today is Matt Harlow and Phil Sang from DJ Case, who are helping us manage and present these webinars. I want to thank them for their hard work to bring you this information today. And I'd like also to thank you, the webinar participants, for your time and involvement in the public scoping process. With that, I'll start up the presentation. Right now, you should be viewing a white title screen for this presentation. Let's stay here just a moment for additional folks to join. It's not advancing. It's not advancing. Before we get started, I wanted to point out how to communicate with us during this webinar. Your cameras and mic controls will be restricted during this meeting. In other words, we cannot see or hear you, but you can see and hear me. However, you will have an opportunity to ask questions, so I want to share how to do that. When we get to the end of the presentation, we'll prompt listeners to submit questions by using the Q&A feature in the webinar controls. Once that window appears, you can type your question into the box and click submit or enter. When we get to the question time period at the end, we'll do our best to respond verbally in the time we have allotted for this webinar. Also, please know that any questions you submit here are not part of the public record. Your official comments can be submitted through the regulations.gov portal. I'll go over that process at the end of this presentation. And lastly, I want to let everyone know that these webinars are being recorded so that they can be posted on our website. We hope this will be helpful for people who want to revisit the presentation or watch later if they could not participate in the webinars at our scheduled times. Okay, so what we will cover in this presentation today is first I'll discuss the service's responsibilities under the National Environmental Policy Act. I'll then provide a brief overview of the Migratory Bird Treaty Act. I'll discuss the change in the interpretation of the Migratory Bird Treaty Act that occurred in 2017. I'll then present the purpose and need for changing the scope of the Migratory Bird Treaty Act, and I'll provide an overview of the proposed alternatives to meet the stated purpose and need. And finally, I'll let you know how you can participate in this process and have your voice heard on our proposal. I want to start with the service's responsibilities under the National Environmental Policy Act. NEPA requires federal agencies to analyze environmental impacts of any federal action and requires us to engage the public in our decision-making process. NEPA also requires us to prepare an environmental impact statement for actions that could significantly affect the quality of the human environment. While we are in the early stages of the NEPA process, we are in the middle of the 45-day public scoping window for this proposed action. This scoping period is an opportunity for the public to provide input on the purpose and need for clarifying the Migratory Bird Treaty Act, issues and topics we should be analyzing in the NEPA document, alternatives we should be considering that we may not have specified, sources of information we should consider, and any other relevant information. This comment period runs through March 19th, and you can provide comments at any time during this stage. I will talk later about specific information the service is seeking from the public. So let's take a closer look at the Migratory Bird Treaty Act and our proposed action. Migratory Bird Treaty Act is one of the oldest environmental laws on the books. In the late 1800s and early 1900s, migratory birds faced an onslaught of threats from unregulated hunting for commercial use, primarily at food sources and for the commercial use in the millinery trade, such as feathered hats. Records indicate that over 2 million birds per year were being killed for feathered hat trade, primarily wading birds such as herons and egrets. During this time, many species were on the brink of extinction, and notable species that went extinct included the passenger pigeon and the Carolina parakeet. As a response to the extinction of the passenger pigeon, the United States entered into a treaty with Great Britain for Canada regarding our shared migratory bird resources. The goal of this treaty was to reduce unregulated hunting of birds and eggs. Migratory Bird Treaty Act was passed in 1918 to implement the treaty with Canada. The Migratory Bird Treaty Act is responsible for bringing many of species of migratory birds back from the brink of extinction to the point where millions of Americans can enjoy hunting and bird watching, contributing billions of dollars to the nation's economy. The Migratory Bird Treaty Act prohibits the taking of migratory birds unless authorized by the Secretary of the Interior. In both 1916 and 1918, the drafters of the Canada Treaty and the Migratory Bird Treaty Act had the foresight to include a system of permits to authorize the intentional take of migratory birds as long as the take is compatible with the Migratory Bird Conventions. In December 2017, the Office of the Solicitor issued M Opinion 37050 to clarify that the MBTA does not prohibit activities that result in the incidental take of migratory birds. By take, we mean to pursue, hunt, shoot, wound, kill, trap, capture, or collect, or attempt any of these actions with the intent of taking migratory birds, nests, or eggs. While it is true that the United States government interpreted the Migratory Bird Treaty Act to apply to incidental take prior to the release of the 2017 M Opinion, the department concluded this is not the correct interpretation. The Interior Solicitor's Office provided detailed analysis of this conclusion in the M Opinion that includes that the Migratory Bird Treaty Act's prohibitions do not explicitly include incidental take. Although Congress has amended the Migratory Bird Treaty Act several times to add provisions that comply with new bilateral treaties or for other reasons, it is not further clarified that take has greater meaning than it has in common law, and federal courts are split on this question under the Migratory Bird Treaty Act. I wanted to explain the purpose and need for the proposed action. Under NEPA, the purpose is a broad statement of goals that the U.S. Fish and Wildlife Service intends to fulfill by taking an action. The need is the answer to the question, why is this action being taken at this time? The purpose of this action is to provide an official regulatory definition of the scope of the statute as it relates to incidental take. The service needs to conduct this action to improve consistency and enforcement of the Migratory Bird Treaty Act's prohibitions across the country and thereby eliminate public uncertainty caused by the current patchwork of legal standards across the different circuit courts of appeal, which have reached different conclusions on the central question of whether the Migratory Bird Treaty Act prohibits incidental take. This approach also aligns and implements the department's interpretation of the Migratory Bird Treaty Act as laid out in M 37050. It is important to note this because this is the driving the reason behind the proposed action. And I want to talk about the proposed alternatives for the draft environmental impact statement analysis. NEPA requires a federal agency to consider a reasonable range of alternatives for consideration, including a no-action alternative. Reasonable alternatives must be economically and technically feasible, display common sense, and must address the purpose and need for the action. The alternatives may not always be the easiest, cheapest, or fastest solutions. The service is proposing a no-action alternative and 3 action alternatives. The no-action alternative is essentially the status quo of how the service is currently implementing M Opinion 37050. This means that we would rely on the M Opinion to define the scope of the Migratory Bird Treaty Act, that we would only enforce prohibitions on purposeful actions, where the intent is to take migratory birds. The service intends to analyze 3 additional action alternatives. These action alternatives describe various approaches that the service could take to provide regulatory certainty regarding incidental take of migratory birds. The intent of this analysis is to provide decision makers with a meaningful range of alternatives to foster informed decision-making and public participation. Action alternative A is to promulgate regulations to define the scope of the Migratory Bird Treaty Act. The scope of the Migratory Bird Treaty Act would be defined to prohibit actions directed at migratory birds. This action would not change the current implementation or enforcement of the Migratory Bird Treaty Act that has been in place since December 22nd, 2017, under M Opinion 37050. Action alternative B would analyze the development of permit system to regulate incidental take. This alternative would establish a framework under which permits would be issued to provide legal coverage for incidental take of migratory birds. To implement this alternative, the Office of the Solicitor would rescind M 37050 and develop a permit system to issue authorizations for incidental take resulting from otherwise legal actions. Action alternative C would analyze the development of an enforcement system to address gross negligence. Under alternative C, the service would enforce the misdemeanor provisions of the Migratory Bird Treaty Act where it could be determined the perpetrator acted with gross negligence. The Office of the Solicitor would rescind the M Opinion and the service would promulgate regulations to define the scope of the Migratory Bird Treaty Act under a gross negligence standard. Gross negligence is defined as carelessness in reckless disregard of the consequences of an action, which is so great it appears to be conscious violation, especially when a reasonable person should have anticipated and guarded against it. So currently we are in the early scoping phase, and we will be working next on a draft EIS process. The public scoping comment period is open through March 19th, 2020. There is one more webinar on March 16th. Please see our webpage for further details. Once the scoping period is closed, we will be reviewing and addressing comments and moving forward with the development of a draft EIS with a rough estimate for completion this spring. The draft EIS will be open for additional public input. A final EIS and a record of decision is planned for fall of 2020. As many of you are aware, at the same time the service published the notice of intent regarding the EIS, we also published a proposed rule. In the interest in providing greater clarity regarding how these two pieces fit, I wanted to provide the timeline for the rulemaking efforts. The timeline to comment on the proposed rule is the same as the notice of intent, March 19th. Based on public input on the notice of intent, the draft EIS, and the record of decision, a final rule will be planned for fall of 2020. You can follow this process and stay involved by following this website, which will continue to update as the process progresses. As a reminder, in this phase, you can provide comments up to March 19th by submitting them electronically in the federal e-rulemaking portal website provided here, or by hard copy address shown here as well. We do not accept email or faxes as official comments. All official comments will continue to be available on the e-rulemaking portal. I'll pause here in case you'd like to write down any of the information on this slide. To better complete the analysis of alternatives, the service is seeking specific information from the public. If you have any information you would like to share on any of the following topics, please submit this information with your formal comments. We are seeking information specifically on the avoidance, minimization, and mitigation measures that entities employed to address incidental take of migratory birds prior to the December 22nd, 2017 M opinion, the direct costs associated with implementing those measures, any indirect costs that entities have incurred related to the legal risk of prosecution for incidental take of migratory birds, such as legal fees, increased interest rates on financing, insurance, and other opportunity costs. We also seek information on the extent that avoidance, minimization, and mitigation measures continue to be employed since the December 22nd, 2017 M opinion. We are also seeking information on quantitative data regarding economic benefits and/or ecosystem services such as pollination, pest control provided by migratory birds, information regarding resources that may be impacted by this proposal, and any information revolving around species that have religious or cultural significance for tribes and species having cultural significance for the general public and impacts to cultural values from the actions being considered. That concludes the presentation. At this time, we will try to address questions from webinar participants. I want to remind you that your phones will continue to be muted, so please use the Q&A feature on the webinar menu. As we go through the questions, we'll try to answer as many as we can. If we get to the end and we didn't get to your question, we'll be sure to provide a little extra time to ensure folks can re-enter their question in the Q&A if necessary. Okay, looks like we have some questions. The first one, how does the proposed rule jive with the Fish and Wildlife Service's mission of working with others to conserve, protect, enhance fish, wildlife, plants, and their habitats for continuing to benefit the American people? The Fish and Wildlife Service continues to be a conservation agency. We'll continue to work with anybody, partner, industry, non-government organization, or general public that is interested in conserving migratory birds, and we'll continue to work with them to minimize intentional take through our permits program that is unaffected by this proposal.
This is also Ken Richkus from the U.S. Fish and Wildlife Service. I'm Chief of the Division of Migratory Bird Management. Just want to thank Eric for the presentation and that answer, but maybe just to follow up a little bit more on that last one, I just would reiterate the fact that the conservation of migratory birds continues to be one of the highest priorities for the Fish and Wildlife Service. Each year, the Migratory Bird Program does provide millions of dollars in grants for bird conservation. We work with other federal agencies, state agencies, conservation organizations, industry, private citizens to help conserve birds in their habitat. You know, we do administer the North American Wetlands Conservation Act, the Neotropical Migratory Bird Conservation Act, and none of those will change with this proposal. The service also manages national wildlife refuges, which provide vital breeding and wintering and migration habitat throughout the country and throughout the annual cycle of migratory birds. In addition, the funds raised from the sale of federal duck stamps go directly to purchase these vital habitats or acquire conservation easements for protection within the National Wildlife Refuge system. And to date, I know the duck stamp program has generated more than $1.1 billion for the conservation of over 6 million acres of habitat in the United States. And none of those will change due to this proposal. I'll go ahead and I think the next question that we have here is why is the service undertaking these proposed rules at this time when a pivotal study published by Cornell University in late 2019 demonstrated that 30% of all North American birds have disappeared since 1970? How does the proposed rule help birds thrive and help their habitat? I'll go ahead and take a crack at this one and maybe have Philip Klein or one of our solicitors follow up. But really the drafting of M opinion M37050 restricted the scope of the MBTA to an intentional take of migratory birds, and that's a legal determination. The Fish and Wildlife Service is the lead federal agency for administering the Migratory Bird Treaty Act, and it's just simply our responsibility to go through the NEPA process, which could result in a regulation that would codify the M opinion. I think that was alternative A that Eric presented in his presentation. So it's just largely us working to codify the current legal interpretation of the Migratory Bird Treaty Act. But again, there's alternate proposals here, and if you feel strongly about either one or do feel that there's a alternative that we have missed and would like to see analyzed in the draft EIS, that's part of what this process is all about here today, and welcome any comments on that.
Yeah, this is Philip Klein with the Solicitor's Office. I don't really have a whole lot to add to what Ken just described. I would say that the Fish and Wildlife Service will certainly consider all available information through the NEPA process, including the recent study by Cornell, and the Migratory Bird Treaty Act, as it's currently interpreted by the Department of the Interior, doesn't reach incidental take of migratory birds. Incidental take of migratory birds is addressed for certain species, under the Endangered Species Act, if they're protected under that statute, various state laws, and there is obviously potential for Congress to enact additional legislation that, may protect or prohibit incidental take of migratory birds without permitting. But currently, the service and the department is not interpreting the MBTA to prohibit incidental take at this time.
Thank you, Philip. This is Eric again, and I'll take the next question. Will all incidental takes, irrespective of the numbers of birds killed or the scale of habitat destroyed, be evaluated by the same measure? How would a massive ecological disaster of the scope of Deepwater Horizon oil spill be evaluated under the new interpretation of the MBTA? First, I'll just remind you that the Migratory Bird Treaty Act does not protect habitat, unlike the Endangered Species Act or the Eagle Act. Migratory Bird Treaty Act only protects migratory birds, their parts, nests, and eggs. As far as the scale of incidental takes, again, the interpretation of the act is that incidental take is not prohibited, whether that's one bird or many birds. And so under the situation of a Deepwater Horizon oil spill, the accidental killing of thousands of birds would not be an enforceable action under the Migratory Bird Treaty Act. However, those incidents still do have to comply with other environmental statutes such as Clean Water Act, Clean Air Act, Endangered Species Act, et cetera. So there still will be environmental protections from those accidents, just not under the Migratory Bird Treaty Act.
Right, and this is Philip Klein again. I'll just add a couple. There is also the Oil Pollution Act, and Superfund under CERCLA requires a natural resource damage assessment when there's an oil spill, where the service and other agencies puts a monetary value on bird species and other wildlife species that are lost through an oil spill, and requires the perpetrator or the owner of the vessel that has the spill to pay that in damages. So there are other statutes that would cover that situation, but under this interpretation, the Migratory Bird Treaty Act no longer will. And the Migratory Bird Treaty Act was previously one of the statutes that could be used in enforcing damages through an oil spill, but the main one is through the Circular Superfund program.
Thank you, Philip. The next question is, will gross negligence factor into the evaluation of incidental take? As we've stated previously, incidental take under this interpretation is not prohibited. And again, whether that's one bird or many birds. However, as we propose the different alternatives, we do propose to analyze an alternative that is focused on a gross negligence standard. So again, if you're interested in a gross negligence standard, we welcome a comment in support or opposed to that approach. So the next question is very similar to one previously. If incidental take is no longer prohibited, which entity or entities will be responsible for cleanup and restoration of habitat should there be a massive ecological disaster, as in the example of the Deepwater Horizon oil spill, which resulted in extensive damage to the Gulf Coast and bird habitat? Will the FWS be creating a new fund to be held by the service to mitigate the effects of such man-made disasters? If not, where will the funds come from for cleanup of man-made disasters? I think we really essentially answered that question. The natural resource damage assessment protocols and other statutes would all kick in. The response would still likely be the same partners, the Fish and Wildlife Service, and all other responders to those incidents. The only change to how we respond to those is the enforcement of those disasters, which we would not enforce the Migratory Bird Treaty Act on any accidental deaths of birds. But as Philip mentioned, there are other statutes, the Oil Pollution Act and the Natural Resource Damage Assessment, along with the ones that I previously mentioned, that still kick in. So I don't believe the response to these disasters changes at all. Okay. So the next question is, when incidental takes result in the destruction of endangered species or endangered species habitat, which law will take precedence, ESA or MBTA? How does the service plan on protecting endangered species from incidental takes, since they will no longer be prohibited? To be clear, the interpretation is for the Migratory Bird Treaty Act alone. Incidental take is still prohibited by the Endangered Species Act, as the statute is written in such a way to clarify that. You need a permit to have take of any endangered species. That continues. This proposal has no effect on endangered species at all. Next question, does the Fish and Wildlife Service project that industries will relax any mitigation practices if this rule is implemented? If not, where will cost savings come from? Well, I think at this point in time, that's an unknown. That's one of the reasons why, as part of the specific information we're seeking in the scoping process, is what kind of measures were put into place prior to this M opinion and the costs that were incurred by those measures, and then what measures are being put into place since the M opinion. We really do need that information so that we can adequately analyze any of the alternatives, including the no action alternative. We're required to do a cost benefit analysis, and that's why we're specifically asking for that information. It's unknown whether industry will continue to implement any of the measures or if they're beginning to relax those measures. So if you have information on that, we certainly invite you to submit that through the comment portal. The next question is, on your questions for comment, are those guidelines so that the conservation needs can also be submitted and requested for consideration? Or will you ignore any replies that do not fall exactly within your questions, which seems more geared towards takes than conservation? Thanks for your consideration. We are accepting all information. We're looking for economic information. We're looking for biological information. We're looking for cultural and spiritual information and how migratory birds fit into the human environment so that we can adequately assess how our proposed action may affect the migratory birds. So yes, if you have specific information or thoughts on additional alternatives that we should consider, or strong opinions on any of the alternatives that we currently have, or have suggestions for other ways to analyze the conservation benefits, we're welcoming all of that through the comment period. So the next question is, if the Migratory Bird Treaty Act only prohibits hunting and poaching, how can we meet our treaty obligations to protect non-game and insectivorous birds? Well, if you go all the way back to the 1916 treaty, the drafters of that treaty had the foresight when they split out game and non-game species and other birds that are both injurious and beneficial to man. They established a series of permits that we still issue today. And so we still issue permits for purposeful take. And that is, we can only issue permits that allow the sustainable populations of those birds. So we will continue to do that, and that is how we will manage, along with the non-regulatory aspects of our jobs, which is conservation of those species. As Ken mentioned before, we have wildlife refuges. We work with many partners, both state, federal agencies, non-government organizations, land management associations, all working for the conservation of migratory birds, which includes the non-game and insectivorous species.
Hello, this is Ken Richkes again from the U.S. Fish and Wildlife Service. And yeah, just to follow up there on Eric's last comment, we'll still continue to work with anybody, any industry, any person who wants to take voluntary measures to reduce their impacts on birds. And I think, again, we have a long history of working with industry to help develop best management practices and provide information to folks that they can use to reduce impacts to birds. And that won't change, again, as a result of any of these alternatives.
I want to thank you all for your comments, and we'll wait here. I don't see any new questions yet. We'll give it a few minutes to see if there's any new questions coming in. But again, thank you for these questions. They're very good. We have a new question. What do you anticipate the impact of the proposed rule on bird populations to be, namely the removal of any incentive to avoid incidental take? Well, I think that's unknown still at this point. That's part of the analysis that'll happen during the environmental impact statement review. Again, reiterating the fact that we are seeking information to help us do that analysis. The more information we have from both industry and non-industry to provide information on how the rule affects birds, we can do a better analysis and look at the alternatives to determine which alternative has the least impact on the environment.
Thanks, Eric. This is Ken again, and just to follow up, as Eric mentioned, the analyses of those different alternatives will be presented in the draft environmental impact statement, and we do expect that to be completed the spring of this year. And that will also go out for a comment period, and the public will have, and others will have an opportunity to comment on those alternatives and the analyses.
The next question is, will pesticide misuse that kill birds be prohibited if the specific birds it kills are not listed in the ESA? So that's a little bit tricky. What happens is our law enforcement would have to do an investigation and determine intent. If the intent of the use of the pesticide was purposely to kill birds, then that would be an enforceable action. If the misuse accidentally killed birds or incidentally killed birds, that would not be an enforceable action under this interpretation. So that would have to be determined by investigating the case itself, and law enforcement would handle that action. Next question, if this rule is effective in the fall, does that mean that enforcement will stop in the fall, or would it have a start date of 2021? Currently, under the M opinion, our law enforcement is not enforcing incidental take currently since December 22nd, 2017, as that interpretation does bind the Fish and Wildlife Service in our policy. So the enforcement of incidental take has already begun to wind down, and it would just continue as is if we chose alternative A, that is. If we chose alternative A or the no action alternative, we would basically continue to see enforcement actions as they currently are being employed. Next question, will you analyze cumulative impacts in this EIS? We will do our best. Cumulative impacts can be tricky. This is a national statute, and so we will be looking at bird populations as a whole. So yes, we will be analyzing cumulative effects. Again, thank you for these comments and questions. We'll wait a few minutes to see if there's any more. I don't see any additional questions coming in. I'll give another 30 seconds in case somebody's typing. Again, I'd like to thank you for your participation in this webinar, and this webinar will be posted on the webpage as a recording, and so you can go back, and as well as any of the other webinars that we've already previously done. Okay, I don't see any other questions coming in, so at this time, oh, one more. So is this PowerPoint presentation available online? Yes, I just mentioned that all of the webinars have been recorded, and they will be posted on our webpage at the URL that I put up before, which I'll just read it out very slowly. https://www.f as in Frank, ws.regulations/MBTA/. You'll be able to find all of the webinars posted there. That includes the PowerPoint, the presentation, and the Q&As. They should be up on that webpage next week, early next week. Okay, I think I don't see any other questions coming in. So again, I thank you for your interest and your participation, and please submit comments if you have comments or information you'd like for us to consider in the analysis. And with that, I'm going to go ahead and end this webinar.